5 seconds to go. Start. Where in any trial of an offence punishable under section 12 or under clause B of section 14, it is provided that any gratification other than legal remuneration or any valuable thing has been given or offered to be given or attempted to be given by an accused person, it shall be presumed, unless the contrary is proved, that he gave or offered to give or attempted to give that gratification or that valuable thing, as the case may be, as a motive or reward such as is mentioned in section 7, or as the case may be, without consideration or for a consideration which he knows to be inadequate. Stop. Para. Notwithstanding anything contained in subsections 1 and 2, the court may decline to draw the presumption referred to in either of the said subsections, if the gratification or thing aforesaid is, in its opinion, so trivial that no inference of corruption may fairly be drawn. Stop. Para. The following are the ingredients of section 7 of the Act, para. The accused must be a public servant or expecting to be a public servant, He should accept or obtain or agrees to accept or attempts to obtain from any person, for himself or for any other person, any gratification other than legal remuneration, as a motive or reward for doing or forbearing to do any official act or to show any favor or disfavor. Stop. Para. Section 13(1)(d) of the Act has the following ingredients which have to be proved before bringing home the guilt of a public servant, namely, para. The accused must be a public servant, by corrupt or illegal means, obtains for himself or for any other person any valuable thing or pecuniary advantage, or by abusing his position as public servant, obtains for himself or for any other person any valuable thing or pecuniary advantage, or while holding office as public servant, obtains for any person any valuable thing or pecuniary advantage without any public interest. Stop. Para. To make out an offence under section 13(1)(d), there is no requirement that the valuable thing or pecuniary advantage should have been received as a motive or reward. Stop. Para. An agreement to accept or an attempt to obtain does not fall within section 13(1)(d). Stop. Para. Pocket and flung them across the wall and the said notes had been obtained from PW3 therein a few minutes earlier, who was shown to be in possession of the notes. Stop. Hence, presumption under section 4(1) of the 1947 Act was immediately attracted. Stop. Although it was a rebuttable presumption, in the said case, there was no material to rebut the presumption. Stop. The accused was, therefore, held guilty of the offence. Stop. Para. Thus, in M. Narsinga Rao, a 3-judge bench of this court approved the reasoning of the 2-judge bench in Hazari Lal. Stop. In M. Narsinga Rao, this court observed that once it was established that there was a demand or payment or acceptance of gratification, and once the foundational facts were proved, the presumption for payment or acceptance of illegal gratification was applicable. Stop. As the said presumption of fact was not rebutted by the accused, the fact of demand was proved. Stop. Consequently, the legal presumption was to be drawn that the said gratification was accepted as a motive or reward for doing or forbearing to do any act as per section 20 of the Act. Stop.